Hello, I'm Sammy Dabbs, the Senior Vice President here at Hound Labs, and I will be hosting today's webinar entitled An Update on State Cannabis Laws and Trends for 2022. This will be presented by Ogletree Deacons and Hound Labs. And what we'll go over today is a review of 2021 and 2022, a deep dive of New York, New Jersey, Connecticut, Pennsylvania, pre-employment testing considerations, medicinal cannabis testing considerations, really what you can expect in 2022 from a federal and state perspective. We'll give you some predictions and trends. We'll review also the importance of recent cannabis use versus past use. And we'll conclude and try and wrap up with some questions and answers for everyone as well. So before we get started, I'm really excited about the presenters today. And I'm pleased to introduce Mike Clarkson and Raina Jones from Ogletree Deacons, one of the premier labor and employment law firms in the country. They both co-chair the drug testing practice group at Ogletree. Among other things, Michael helps a broad range of clients draft drug testing policy, and Raina represents clients of all sizes on all aspects of employment law and advises on state-level marijuana laws and multi-state drug testing issues. We're delighted to have them share their expertise this morning, along with Doug Boxer, who is Hound Labs Chief of Policy and Strategic Initiatives. Doug has a long history of working on public policy and helps influence state legislators to take a balanced view of shared interests of employees, employers, unions, law enforcement, and needs around cannabis legalization. So with that being said, I'll go ahead and kick this off and hand it over to our first presenter.
Thank you, Sammy. This is Doug Boxer, Chief of Policy at Hound Labs. It's a pleasure to be here today. Thanks for taking some time today to learn about these important issues. So I'm going to speak to slides 4 and 5, which is really an overview of where we stand with marijuana legalization. And many of you probably already know that 2021 was a very active year for cannabis reform. You can see there that 5 states were able to legalize adult recreational use of cannabis by legislative acts. And because it was an odd year, and I don't mean it was a strange year, the number 2021 is an odd year, most of the activity surrounded legislatures. In the even years, as many of you know, we have election years, and that's when we see ballot initiatives pass. So the important takeaway from here is we're now at 18 states plus DC that have recreational laws on the books and 32 medicinal laws. We increased by 40% in 1 year in 2021, with some very large states, including New York and New Jersey, on the list. And important to note that even what would be considered a southern state, Virginia, passed marijuana legalization as well. We did have 2 setbacks, at least in terms of where the advocates stand, in South Dakota and Mississippi, where recreational use law in South Dakota was overturned by the South Dakota Supreme Court, and same thing in Mississippi with the medicinal law, and we'll talk a little bit about that later. Sammy, next slide, please. So really the takeaway here, folks, is that you see on the top, the tipping point has arrived. That means we are really not going back on marijuana legalization. It is here to stay. The vast majority of adults in America now have legal access to cannabis and can use cannabis for personal use. Obviously, it does not mean they can go to work impaired, and they certainly can't drive under the influence of cannabis. It was over 55 million current users, and the map is really there to see that this green color in our parlance here is taking over. We do expect 2022 to see increases in public policies around this issue. Really important to note that as you find increased access and tolerance to use of marijuana, an employment policy, and Mike and Raina will talk to this, that requires zero tolerance of marijuana use is going to be increasingly impractical, we believe, for you to enforce. Next slide. I'll turn it over to the Ogletree team.
Hi, this is Raina Jones. So we're going to do a little bit of a deep dive first to kind of go over some key legislation that impacted employers in 2021 and will definitely continue to impact employers in 2022. We saw a lot of interesting legislation out of New York. with the new cannabis law there and the DOL guidance that's recently come out. We're also going to talk about New Jersey and their cannabis legalization law and what these workplace impairment experts are. And then we'll also talk about new legislation in Connecticut for recreational marijuana, and then the city of Philadelphia that has banned pre-hire cannabis testing. All right, let's talk about New York, because this to me has been one of the most challenging states. As everybody knows, effective March 31st, 2020, New York amended their prior lawful product statute. So basically they had a statute that prohibited employers from discriminating against employees and applicants based on lawful outside off-duty activity. And they amended that statute to include the use of cannabis in accordance with state law as a lawful outside workplace conduct. So now in New York, employers are prohibited from discriminating against applicants and employees based solely on legal use. Now, employers can still prohibit use in the workplace, including meal times and rest breaks, use while the employee's on call, or possession on company property and vehicles. There's also some carve-outs for required drug testing under state or federal statute. Also, if the employee is impaired at work while performing their job duties, employers can still take action. And also, employers can take action against recreational use if it would require them to, if they would lose a federal contract or federal funding by not, prohibiting marijuana use. Now, it's interesting because the New York Department of Labor came out with some FAQs just a few months ago. And basically what they said is that, in order to take action based on impairment, you've got to rely on specific articulable symptoms of impairment. Now, there's no definition of that, but they said it's objective, observable indicators that the employee's performance of their duties or their positions may be decreased or lessened. And the example they gave was something like operation of heavy machinery in an unsafe or reckless manner. Now, what they said would not be objective, articulable symptoms of impairment would be something like odor, or maybe the employee has red eyes, because those don't go to the decrease or lessening of the employee's performance. They also addressed drug testing, and they said basically that drug testing is not a basis to rely on for an articulable symptom of impairment. And what they further went on to say is that you can only drug test if permitted under the statute. So if required under federal law, think your DOT employees, or if you've got employees who are impaired while working. So it's pretty interesting where the DOL went, because notably the marijuana statute did not prohibit drug testing in any way. So, personally, my read of it is that the DOL overreached. So it'll be interesting to see where we end up with that. But as of right now in New York, we are really limited in our ability to do drug testing for cannabis. And now I'm going to pass it over to my colleague, Mike Clarkson, to talk about New Jersey.
Hey, thanks, Raina, and welcome everybody. Glad you're here. I suppose your handoff about overreach is great, because New Jersey is really out at the cutting or even bleeding edge of this space. And I think as you sit here and try to absorb all this information about New York and New Jersey, and then soon to follow Connecticut and Philadelphia, it's hard. It's hard to keep all of this stuff straight and to keep the differences straight, but we'll do our best to unpack this for you. So New Jersey's recreational recreational marijuana law was effective January 1 of 2021. And in essence, it really made marijuana use, recreational marijuana use, some sort of new protected class in New Jersey. You'll see this fourth bullet here: adverse employment decisions made, quote, solely on the basis of recreational use are prohibited. So, recreational users have job protections in New Jersey. That's not true, of course, in every recreational marijuana state. As Doug has indicated, this is really coming on strong, but New Jersey provides this sort of job protections for them. Perhaps unlike many of the other states, New Jersey does not provide a safety-sensitive exemption, which is itself remarkable too. They set up this workplace impairment recognition expert wire process, but the statute sort of created this wire expert before there was any such wire expert, and even recent regulations that were issued in August of 2021 didn't address wire certification. So a lot of this is still a work in progress, but I think it's fair to say the trend line is in this direction, that we can expect to see more statutes like New Jersey, and certainly one to pay attention to even if you're not in the state of New Jersey. So what can you not do in New Jersey, right? You can't take action on just a positive test or on off-duty use. You can take action as an employer on use, possession, or intoxication at work. There's this federal contractor carve-out, but the interplay between the New Jersey recreational marijuana use, its medical marijuana statute, lawful off-duty conduct statutes, et cetera, are still unclear, really. And this will take shape as further regulations come out, particularly regulations about this wire certification and the wire experts, but also as court decisions sort of put flesh on the bones here. Connecticut, the next slide, is interesting too. If New Jersey is the outlier, Connecticut is probably more typical, if you will. The employment-related provisions will go into effect in July of this year, so July of 2022. But they have employment protections. Employers may not discharge or take any adverse action against employees or applicants with respect to their compensation terms, et cetera, based on their recreational cannabis use outside the workplace. And as with New Jersey, right, employers still can prohibit from using, possessing, or be impaired by cannabis during the workplace. This is more typical, whereas New Jersey, I think, has gone farther. So if you were looking for a pattern, New Jersey is a good, or Connecticut is a better pattern, but better pay attention to New Jersey with this in mind. Roll up, if you will, Sammy, to the next one. This is Connecticut continued. Connecticut does have some interesting provisions, though. Look at this first bullet, right? Employers cannot refuse to hire or terminate based on positive results for this particular tetrahydrocannabinol. If anyone can correct me on that, that's great, but I think I got that right. These are the non-impairing metabolites. Delta 9 and Delta 8 are the impairing ones. So interesting, right? Connecticut is trying to distinguish between impairment. They're trying to find a way to delineate between the metabolites which they associate with impairment and those that they don't. Here's another really interesting thing about Connecticut. Look at the last line of this slide, right? Employers may continue to take adverse action for violations of a written policy prohibiting recreational cannabis use. As an employment lawyer, this exception seems to swallow the rule, at least for those employers whose policies are up to date, and that may be that's more difficult in practice every day. But if you have an up-to-date policy that says, hey, we prohibit recreational cannabis use, the Connecticut law allows you to take adverse action. It also exempts certain employers: mining, utilities, construction, manufacturing, transportation, education, healthcare, etc. That's a fairly long list, right? It also exempts certain positions at any employer, right? Positions requiring commercial driver's license. Well, that's true anywhere. The DOL rules trump here. But safety-sensitive positions as determined by the employer, right? So you can define what is safety-sensitive. Positions involving the care of children, medical positions, etc. Law enforcement, firefighters. So by the time you're done exempting certain jobs, and by the time you're done exempting certain employers, there may be a fairly limited class of jobs and employers that are still covered, and an employer who didn't want to do this could have an up-to-date written policy. But that said, Connecticut is still one to pay attention to. There are private causes of action here too, back pay and attorney's fees. And if anything we've learned out of the state of Pennsylvania is that you waive back pay and attorney's fees in front of the plaintiff's bar, and there will be an active litigation. So I think we can expect that here in Connecticut too, starting when this takes effect this summer. Let's see. Let's go then to at least to Philadelphia, Pennsylvania, and back to Raina to talk to you about what we have there.
Thanks, Mike. Philadelphia is joining joining our list of jurisdictions that are now taking action against pre-employment marijuana testing. This is basically one example. We already had New York City that had a similar ban. New York City's kind of been swallowed up by what we just talked about when I talked about New York State, that now the entire state of New York, based on the DOL's interpretation, you can no longer do pre-employment marijuana testing in the state of New York. So I think the city prohibition is somewhat moot at this point. Nevada is another location. The state of Nevada also has prohibitions on what you can do with pre-employment marijuana testing. Nevada is a little bit different. It allows pre-employment marijuana testing, but in Nevada, you can't take action based on a positive test for marijuana. So really, that pre-employment, those applicants are really protected. They're off-duty use. Fortunately, in Nevada, we've got some carve-outs for safety-sensitive positions that are pretty expansive. So now Philadelphia has joined the list effective January 1 of this year. Like Nevada, Philadelphia has some exceptions to their prohibition. So police and other law enforcement, commercial driver's license holders, supervision or care of children, medical patients, or people working with disabled and vulnerable populations. And then they also have a safety-sensitive carve-out, but the language is very different than Nevada, which kind of gives the employer the discretion to determine what is safety-sensitive. In Philadelphia, the ordinance basically says that it's as determined by the Philadelphia Commission on Human Relations and as set forth in their regulations. Now, the Philadelphia ordinance went into effect January 1, and we still don't have any regulations from the Philadelphia Commission on Human Relations. So at this time, I think employers really have to wait before they can rely on this safety-sensitive exception. We just don't have any guidance yet onto what will fall under this exception, so we'd really just be guessing. And so for now, there doesn't appear to be a carve-out other than the ones delineated in the statute. And then, of course, it also has a carve-out, like all of these statutes, for testing required by federal or state statute or required by government contract or grant. So again, if you've got DOT drivers, this is not going to affect that. If you have a specific federal contract that requires some type of drug testing, this is not going to prohibit that. But merely being a federal contractor, similar to like in New York, merely being a federal contractor will not be enough. It's only if the testing is required, not just permissible by law. And then also if there's testing required by a collective bargaining agreement, that you would still be able to conduct pre-employment testing in Philadelphia subject to that agreement. Now, the law is solely focused on pre-employment testing. So it doesn't address the testing of current employees. It doesn't prohibit you as employers for disciplining employees from being under the influence work or prohibit discipline for the possession or use at work. So this is solely based on your applicants for employment. And let's turn it over. Next slide.
So if recreational adult use marijuana has been where a lot of the development has taken place in the most recent years, as we've just summarized, medical marijuana has, I think we've been able, because we've got at least a few more years head start, to get maybe a slightly clearer picture of where what employers' rights and obligations are. Now, that's not to say that every state is the same, right? It's still a patchwork of state and even sometimes municipalities' laws, but it's been around a bit longer, and so we have a slightly clearer picture. There's really three ways to break this down. The first is there are medical marijuana statutes with statutory protections, right? They include anti-discrimination provisions in them. You know, when Raina and I were first sort of rolling this stuff out, these were the ones that were easy to identify. And although it wasn't entirely clear when these statutes were first written what anti-discrimination meant, you know, we could find them in the statutes and we could advise our clients. These states are fairly easy to identify. I'll let everybody grab their pens. I'm going to rattle them off now. Arizona, Arkansas, Connecticut, Delaware, Illinois, Maine, Minnesota, New Jersey, New Mexico, New York, Nevada, Oklahoma, Pennsylvania, Rhode Island, South Dakota, and West Virginia. Now, that's actually a really interesting list, isn't it? And we'll talk about some of the conundrums in that, right? But those states, we could say, okay, right, employers ought to be careful. There's this anti-discrimination provision. And the second thing in here, and it's reflected in the middle of this slide, right, does not apply to DOT regulated positions. You could say the same thing about FAA regulated positions, right? NRC, Nuclear Regulatory Commission, you know, nuclear workers. Certain areas where the federal law prevails and preempts state laws to the contrary, right? So your commercial driver's license holder, your tractor trailer driver can't use marijuana even if he or she is in Arizona, Arkansas, Connecticut, Delaware, et cetera, right? The tricky part is this third part, and down at the bottom here, there are medical cannabis laws without protections for employees and applicants. And the court created protections that have come along, right? So in the earlier years, the courts seemed to find that states that did not have those anti-discrimination provisions in them did not provide job protections. And in one form or another, courts in Washington, California, and other states said, well, if there isn't that anti-discrimination provision, this medical marijuana statute is just decriminalization, right? The cops can't arrest you for buying, carrying, using medical marijuana, right? But it did not impose any obligations on employers. But over the last 4 or 5 years or so, courts, including in Connecticut and Rhode Island early, and then later in Massachusetts and New Jersey, found under one sort of theory or another that these medical marijuana statutes did create job rights despite not having anti-discrimination provisions, right? The Massachusetts example is a good one. Here they said, well, the medical marijuana statute doesn't provide any rights, but the state's disability discrimination laws, here it's called, I'm in Boston, it's called Chapter 151B, does, right? And employers have to accommodate the medical marijuana use, not under the medical marijuana statute, but as a disability discrimination concept, right? So you'd have to accommodate that much like you do a reasonable accommodation of somebody's physical limitations or other prescription drug use. The trend line, if there is one, is certainly towards this job protections created by judges, even where the anti-discrimination provision isn't in the statute. So beware, I think. I mean, how long will California remain a state that does not provide this protection, right? It's probably, months, not years, until somehow or another California extends those kind of job protections. But that's the lay of the land for medical. Confusing as it is, I suppose it's less confusing than the state of the law in recreational. Sammy, if you'll roll us up a slide. Here you go. So here are the states with the job and anti-discrimination protections, either by statute or by court decision, right? What's most telling in this slide, right? Well, where's California? And why is West Virginia in there, right? Why is South Dakota in there? You know, Doug sort of referenced this a bit on his slide early in this presentation. This is an interesting list of states that provide these job rights, right? What is and is not included. And if anything, I mean, West Virginia and Oklahoma and the like are rarely accused of being progressive, and where is California? So you know this stuff is a little weird and difficult to predict when you see a list of states like this. Hard to predict who's next, but if a judge can decide that those job rights exist, it can be very difficult to predict, right? Raina and I can read the statutes with a lot more certainty than we can predict what a judge is going to do in some things. And while the judicial decisions so far have tended to focus on disability discrimination, and while we do have a Colorado Supreme Court decision which rejected lawful off-duty conduct as a basis to extend job rights, I think it's only a matter of time until that concept, right? It's legal. Why can an employer take action against you for doing something legal, right? Lawful off-duty conduct is extended somewhere. So, and if anything else, the fact that medical and recreational marijuana is big business would suggest that we're going to be adding states to this list, right? John Boehner, once you know, very prominent Republican, left Congress and went on to lobby for marijuana. So it'll sort of show you that the world has shifted with 183 million, as Doug indicated, people with access to marijuana, as Doug indicated in an early slide. This has changed and is certainly continuing to change very quickly. So that's the lay of the law as it is. Check in with us in a month. There'll probably be another state on that list. Doug?
Thank you. And folks that are listening, I mean, you just heard from Mike and Raina, really subject matter experts on what happens after a state legalizes either medicinal use or recreational use, right? The states are really the laboratories under which this is all occurring. And so it's good to, and we picked these states and jurisdictions intentionally so that you could see the differences, the experiments that are happening in these laboratories. And I use those words intentionally because the states that are acting more recently have the benefit of looking back to see what other states may have done or may not have done to ensure that their legal framework is maybe more solid. So I would point to the Connecticut provision, for example. Now, full disclosure here, we're Hound Labs, and you're going to learn a little bit about technology in a second, but our breath test has a window of detection, which is just only a few hours, and it only detects the impairing substances that are in cannabis. It does not detect that metabolite that Connecticut said you can't, if you have a test that detects that metabolite only, you can't take an employment action. So we can see that legislatures are beginning to try to create laws that are fairer, that balance safety and fairness, and that's really what our technology is about. But we'll leave that for Sammy's slides in a second. So you know, look, the question that everyone wants to know is what's Congress going to do in 2022, and I think despite the fact, you look at the tailwinds on the list on this slide on the right-hand side, despite the fact that there's overwhelmingly popular support for legalization, and legislatures are loving the fact that they're generating, in some cases, hundreds of millions of dollars of revenue from legalization of cannabis, I still think that Congress is not going to get it done this year. I think there's just too many things standing in the way. You see a few of them listed there. There are a few legislative days this year because of the midterm elections that happen this year. You've got COVID, which is still raging in many parts of the country, which is occupying everyone's time and energy. You have these recently increasingly agitating geopolitical issues surrounding Russia and other areas. And so I just don't see them coalescing around something that would act. Now that's problematic because now if you're an employer and you're sitting there thinking about, my gosh, Raina and Mike just walked through all these different things I got to deal with, I think unfortunately you're going to have to continue to deal with those different state laws and jurisdictions. Congress could step in and maybe rationalize drug testing laws, but I just don't think that's going to happen this year. So the moral to the story is, unfortunately, Mike is right. Come back in a month and see where we're at. If you go to the next slide, Sammy. So this is what that is. This is a description of what we think may happen in the states. Now, look, you all probably read the headlines like I do. Every day, a different state, there's a headline about the advocates introducing legislation to reform cannabis laws. Don't get caught up in all the headlines. In my view, a lot of those headlines are obviously being pushed for specific political reasons. There are some who will probably act. For example, South Dakota, whose Supreme Court I told you earlier had overturned their medical law and their recreational law. It's likely, despite the fact the governor is putting up some roadblocks, that legislature may act. Mississippi, the legislature might act, but the governor is saying that he may not want to approve it. What I probably can tell you is that Delaware and Rhode Island are probably going to act this year, and then we'll have to see. It's very hard for advocates in states that have statewide referendums to collect the signatures needed to get to qualify these ballot initiatives for the ballot because of COVID. And so we're seeing lots of efforts in various states. Their advocates are now announcing they're going to wait until 2024. That happened in Florida. Florida had a very aggressive advocate effort to sign, for people to sign petitions to get on the ballot this year, but they announced they're just having a hard time. And then I simply put a list of a few states down below. Obviously Florida's there, but Indiana and Kentucky, you could pull quotes out from different places. I think at the end of the day, the important takeaway here is that there's going to be activity in 2022. And it's important for you all, depending upon what state you're in, to track the headlines carefully. And then you're going to want to listen to this presentation later this year or next year when we update what these states have done. I do think, however, states are getting smarter about their efforts. The final point I make is Raina walked through the New York Department of Labor guidance. I think it's completely disconnected from the reality of what the legislature intended when they passed their recreational adult use law. I do not think the legislature intended to eviscerate drug testing, cannabis drug testing in the employment sector. I just think the Department of Labor, that's how they interpreted it. And I expect there will be guidance, which hopefully balances the scales between fairness and safety. And with that, I'll turn it over.
Thanks, Doug. I agree with Doug on I just don't think we're going to see any type of federal legislation this year, just with all the challenges. And so for all of you as multi-state employers, it is going to continue to be a struggle to try to keep up with all these different cannabis laws in these different states. And Mike and I, on a pretty much daily basis, counsel clients across the country on drug testing issues and marijuana issues. And one thing I think Mike and I often talk is that we definitely see some trends, and I think based on what we're seeing, we can also make some predictions for you. And so the first thing I want to talk about is fairness, and I think I've hit on it, and Mike's hit on it, and Doug's hit on it. We are going to continue to see more rights for cannabis users. That's definitely not going away. That's definitely the trend. There have been legislation that hasn't gone anywhere, but it's going to keep getting posed. I mean, I know Florida had something, Hawaii had, to protect medical users. So I think we're going to continue to see, states and local jurisdictions following, what's been done, what we saw in Connecticut and New York and New Jersey in putting in place protections for recreational users. More types of bans on what you can do as far as pre-employment testing, like we saw pass in Philadelphia. There was also Montana. Montana now, starting this month, protects off-duty use of marijuana. And so I really think that is the trend, and we're going to see more states, whether it be by ballot initiatives or whether it be by legislation, put in place more rights for cannabis users. And so I think when you're drafting your policies, you really need to be thinking about, you just can't have language in your drug testing policies anymore that has kind of, well, marijuana is illegal under federal law and we prohibit it as a company. You know, unless you're only in states that have not, you know, legalized medical marijuana, have not legalized recreational marijuana, and there still are some states, you really cannot get away with that anymore. And so we've really been focusing on revising employers' policies to kind of reflect what's really going on, um, you know, in this space as far as marijuana, and kind of write policies to give employers more flexibility to be able to take action if they want in states where they can, but kind of address those different variations in state law. So for the employers that maintain the status quo and don't kind of adapt to what we're seeing, to all these legalization statutes and job protection statutes and case law, I think you're going to face the possibility of more lawsuits. We have seen, you know, I get a dinger every time there is a medical marijuana, a recreational marijuana lawsuit filed in the employment context. And used to be, I would see very few of these alerts, and now they're coming up on you know, multiple times a week, if not almost daily. The Pennsylvania, New Jersey have really been hotbeds for litigation. A lot of plaintiffs' attorneys have kind of made a cottage industry out of it. We've got one here in my state of Arizona where, you know, this plaintiff's attorney, he goes around and he sues employers for violations of our Arizona's medical marijuana law. And a lot of times these cases are hard to defend because the employer has violated the law. You know, they've kept some old policy where they have just taken action based on someone's medical use. And so I think you're going to see more lawsuits, whether it be under the marijuana statutes, medical or recreational, or disability claims like Mike talked about. So I've seen a big uptick in EEOC claims where they're related to the employee's medical marijuana use, or under the state disability statute, and they're claiming that, you know, really the discrimination is based on their underlying disability. And so I think this is an area where you as employers are just going to see more and more of these types of claims if you don't do a better job addressing, both from a policy standpoint and from implementation, how you address these, you know, different medical and recreational marijuana situations. Now, the number one question I get right now, and that I've been, you know, getting for the last year or so, is employers calling me and saying, look, I'm looking at dropping, you know, pre-employment testing for marijuana. You know, it's a hard job market right now. I'm having trouble finding employees. You know, marijuana is legal in a lot of states. Should I drop pre-employment testing for marijuana? And some employers are also looking at, should I drop testing for, you know, in my random testing program? And I think there's a lot, you know, and what I typically do is I talk through the, you know, with my clients on what the risks are, but absolutely the trend is towards moving away from that type of pre-employment and random testing for marijuana, especially in non-safety sensitive industries. The vast majority of companies that I work with have dropped it, especially in retail space, in hospitality, in jobs that are more office type jobs. You know, we're really looking at, do we need to be doing pre-employment testing for marijuana, especially in states where it's been legalized, even if there's no job protections. And so that is certainly the trend, and I think we will continue to see a shift. I mean, I even have employers in those kind of safety sensitive, you know, with a lot of safety sensitive positions, even my manufacturing clients, who are also looking at and have implemented, you know, changes to their drug testing policies where they're no longer either pre-employment and or random testing for marijuana. Now, with us seeing more and more, you know, access to marijuana, right? We've got all these states that we talked about where recreational marijuana is legal and medical use is legal. I think it's so important to focus on the training of supervisors and managers to spot impairment and to know when to do a drug test. And so that's something I've really been focusing on in the last year is let's put in place a good policy that addresses marijuana, that addresses reasonable suspicion testing. And then let's train our managers, because it's a hard thing to do if you don't know how to do it and you've never done it, to go up and approach an employee that you work with on a day-to-day basis and tell them that you think you're under the influence and that you're going to send them for a drug test. And so really try to do some training and put tools in place for our supervisors and managers, one, so they can spot impairment, and then also so they can have those tough conversations, know what they can and can't say, know what the process is for doing drug testing, and then, to really get those employees tested when there's reasonable suspicion. Because even though we may be, hey, we don't care what you do in your off-duty time when it comes to marijuana, we still want to keep a safe work environment. And so that really does shift a lot of the onus onto our supervisors and managers to make sure that employees are coming to work and they're fit for duty. And because we're focusing less on that off-duty use of cannabis, and we really are focusing more on what's going on when employees are working, the problem is that's going to further complicate our use of traditional cannabis tests, right? So if you are an employer that does post-accident testing, like let's say I've got an example, I've got an employer that anytime anyone is involved in an accident with one of their forklifts, they do post-accident testing. But they don't do pre-employment marijuana testing. They're really not interested in regulating what their employees do off duty, but they do post-accident testing. And so if they're doing urine testing, they're going to be not looking at impairment, but at recent use that could go back up to 30 days. So I think employers really have to think about how both their policies and the practical implications of them and what they need to do to make sure that they're really focusing on what are we trying to prohibit? We're trying to prohibit impairment and use in the workplace. And then I do think we're going to continue to see exemptions for certain employers, positions, and types of work. So, look at obviously federally regulated positions. So your DOT, FAA, those are going to continue to be areas where you're going to continue to prohibit marijuana use, you're going to continue to test for marijuana, and you're going to take action based on marijuana use. Also for safety sensitive positions, I mean, some of the medical marijuana statutes like Arkansas, New Mexico, Oklahoma specifically carve out safety sensitive positions from their statutes. A lot of our medical marijuana statutes do not. The majority do not. And so really looking at treating medical marijuana like we would for other prescription drugs and engaging in the interactive process like Mike talked about and determining, is there a direct threat here? Can we as an employer, based on what this person's job is, can we accommodate their off-duty use of medical marijuana? And then, for recreational, majority of states don't have protections yet, but obviously, as we saw with New York and New Jersey and Connecticut, that's changing and kind of addressing, are there some exceptions there? And, there's not going to be a lot of exceptions in New York or New Jersey, but still being able to test for impairment. So I do think that we really want to focus on making sure we've got those good policies in place to kind of address all these different issues that we've talked about. And now I will turn it over to Sammy.
Great. Thank you, Raina. So I really love the sentiments there, Raina, on off-duty use. More and more we are hearing from employers around off-duty use and how they no longer care what employees are doing on their own time, after hours, not before showing up to the job site. So this is a slide that many of you have probably seen in the industry. It's the detection windows of cannabis across multiple methodologies here. So what I wanted to show you is the THC in breath only lasts about this 2 to 3 hour period of time. In comparison to oral fluid, urine, and hair testing, you're looking at about this 24-hour period in oral fluid testing, about a month in urine drug screening, and 3 months in hair testing. testing. So the key call out here is this peak impairment window, and determining recent use has become paramount for employers. That being said, there are some unique properties of THC and breath, and breath technology is very important. As you heard from Mike and Doug today on Connecticut, for example, breath technology is only detecting the psychoactive ingredients in THC. That's a really, really key point as you see those protections for employees state by state. THC in breath is also detected in parts per trillion, and that's what results in THC not being detectable after that 3-hour period. So that 3-hour period is very important for employers as you're looking at your policies state by state. As you heard today from Mike and Raina and Doug, really that state by state policy and this 3-hour time frame is significant because research has shown it's when people are most likely to be impaired. So the breath technology correlates very well with that peak impairment window. Another marijuana tests, as you saw on the previous slide, urine, blood, oral fluid, hair, are detecting past use and well outside of that impairment window. All right, we'll go ahead and wrap up today. In conclusion here, you heard today from our experts about 2021. It was very busy. It was a consequential year for cannabis reform. A lot of those employment protections, significant consequences for employer testing, really that fairness factor, limiting tests that provide positive results for those non-psychoactive metabolites. So state by state, those policies that were coming out. More guidance needed on some newly adopted laws. So really partnering with your legal counsels on guidance for the ever-changing laws that are going on. And in 2022, you heard from Doug on potentially even more activity here. So a lot of limits on employment action based off non-negative tests for non-impairing metabolites. Additional employment protections we'll likely see as more states grapple with legal status of cannabis. And new technologies. So technologies like breath, the Hound marijuana breathalyzer, to help employers and employees detect only recent use and not past use. And certainly federal cannabis reform law, right? I mean, Doug mentioned crystal ball's cloudy here. We'll see what happens in the coming months in 2022 about federal cannabis reform. So with that all being said, I really would like to thank our presenters for today. Here's a quick disclaimer. Hound marijuana breathalyzer, our technology is intended to detect recent marijuana use. It does not measure whether or how much a person is impaired. It's intended solely for the use in law enforcement, employment, and insurance settings, and is not to be used for any medical or therapeutic purposes or for any federal drug testing programs such as SAMHSA, DOT, U.S. military. And so before—
Hey, Sammy.
No.
Sorry.
Well,
when we were, for everybody, when we were, doing a dry run of this, Sammy, I threw out sort of how these calls that Raina and I have both mentioned tend to go, and Sammy thought it was sort of illustrative. So let me give you guys the benefit of that in case it's helpful, right? What we hear at Ogletree when multi-state clients are calling with these conundrums is something like this. And this actually fits in really well with Hound may really be offering up on something important to the marketplace, right? We've got maybe a libertarian CEO, right, who says, I don't care what you do on the weekends, right? Just show up sober. We've got a staffing person who says, oh my God, I can't get enough people in the door, right? We're suffering from this hiring crisis that we're all reading and hearing about so much. We've got a legal team or a HR compliance team who's pulling out their hair thinking, oh my God, we've got to comply with this law, but what about that law? What about this one that provides medical protections and recreational protections? And what's a wire expert in New Jersey, right? And we've got a safety manager who is petrified that if they, as the company, eliminates marijuana testing, that somebody's going to get hurt, right? And that is a conundrum, right? There aren't easy answers to this. And, people say safety first for a reason, right? And so I tend to prioritize that. But, compliance and staffing, these are super important things too. One of the really interesting things about the Hound technology, and when I've had clients on the call with this, I've thrown this out, which is it may actually be a bridge between all of these competing interests, right? If you say, hey, we can't continue to test for something that flags marijuana use days, weeks, or in hair even months ago, right? That doesn't make sense. We can't get enough people. We're spending a lot of money. It may not be compliant with state X, state Y, et cetera. But if Hound, with its window and with its focus on the impairing metabolites of marijuana, might satisfy that safety manager who says, I really got to be concerned about that, but also satisfy this other stuff. So it's an interesting technology, but you know, with your C-suite may be in exactly that same situation, trying to bridge between all of these competing interests. It's tough. It's an area to watch, but you know, Hound may provide a really, I'm not trying to give a sales pitch, I suppose, but may provide a really interesting and valid bridge between all of these competing things. And when I've described it to various clients, they said, "Oh, you know, that might be what we're looking for." So, lots of things to consider, and certainly an area to watch. If we gave the same presentation 3 months from now, we'd probably have another state or two or some regulatory updates. So, one to pay attention to, and really thank everybody for being a part of this.
Thank you, Mike. I appreciate that. And we do have just a couple questions today that we'll go ahead and ask our presenters. So first question, and I believe this should go to Mike and Raina, is if I have employees who live in legal and non-legal states, how does that impact my testing program or plan?
I'm sure either of us could do this. This, to my knowledge, is sort of an unanswered question. I mean, living in Boston, right, where state lines are, you know, you can't throw a rock without crossing a state line here, it seems. There's an interesting choice of law analysis, right? If you live in New Hampshire and work in Massachusetts, which state's law applies? This is really something that hasn't been answered yet, to my knowledge, and might really create all sorts of problems. And until we have, you know, a federal law that preempts, but I agree with Doug's cloudy crystal ball that we can't expect that this year. There's enough else going on. Until we have that, we're going to have competing state laws with different rules, and cross-border issues there are super complicated. Do you agree, Raina? Anything I'm missing?
Yeah, no, I agree, Mike. I think also what I'm seeing, because obviously employers have to address it, right? But the way I'm seeing a lot of employers addressing it, and obviously there are issues with the cross-border, but just taking it more simple. I've got employees in New York where I can't do, you know, I'm very limited in what marijuana testing I can do, and I've got employees in Texas where I can do anything I want. So I think a lot of that comes down to drafting of your policies and implementation, and determining how you as an employer want to implement. So, you know, I have some employers who said, you know, we really want to be consistent across all our jurisdictions. So if we have some, you know, jurisdictions where we can't do something, you know, maybe we want to take that approach. A lot of what I see is an approach of more, there is a little bit of a state by state to it. So when we draft our drug testing policies, and there are a lot of different state laws regarding drug testing as well, not just marijuana, which I'm not sure a lot of employers even realize that some drug testing laws, there are several states that regulate private employer drug testing and have specific requirements. And so I think a lot of that is policy and procedures in place. All right, this is how we're going to address it generally. So here's our general policy, but we're also going to need carve-outs for particular states. And there are just going to be some state differences, right? If we still want to test, but we can't do it in New York, well, we still want to test in our 20 other states that we are. And so I do think a lot of it comes down to drafting, to putting in place procedures on how it can be implemented. I do a lot of cheat sheets for employers to go with their policies, where so they can look at it and go, okay, what's different if I'm in Connecticut? What do I need to do if I'm in, you know, Arizona? And so I think that's helpful. So I think a lot of it is putting a lot of procedures in place and process in place to help the people who are implementing these drug testing programs, and then also training. I think training is the other aspect, is training, whether it be, HR or safety as far as the procedures, and then training our supervisors and managers, like I talked about earlier, in understanding the policies and understanding when they test, making sure in their jurisdiction they understand what's allowed and what's not allowed.
Thank you, Raina. That was great. And Mike, I appreciate that. Another question here from our audience is, when will the Hound marijuana breathalyzer be ready? And I'll go ahead and take that one for the group here. So we at Hound Labs have ship dates throughout 2022. So I do encourage you to pre-order with either Hound Labs or your partner. So if you're working with a partner like a third-party administrator or collection facility, please work with them for that pre-order and let them know, how many tests you'll be using throughout the rest of the year. That'll be very helpful as they look to their projections and our projections certainly here at Hound Labs as well. Please feel free to email me if you have any additional questions after the webinar. You'll see my email here, sammy.dabbs@houndlabs.com, and I'll work with Mike and Raina and Doug in getting all the rest of the questions answered. And on behalf of Hound Labs and our guests from Ogletree Deacons, we really do hope that you found today's presentation informative and helpful. We appreciate all the attendance. You will receive a follow-up email within about 48 hours to view a recording of today's webinar. And again, thank you to our presenters, Raina, Mike, Doug. You guys were great. Thank you so much.
Thanks for having us.
Thanks, everybody.
Thank you, everyone.